Paul, yeah. I was looking at the letter V, yeah. And the word is valid, legally binding, sufficient, justifiable, complying with necessary regulations and formalities. Then there's a validating statute, a law that corrects, adds to, alters, or deletes material from a previous law, statute, thus making the amended law valid. The state of being legally sufficient and valid. Validity of a statute, the effectiveness of a law insofar as it relates to its constitutionality. An invalid statute may be thrown out because it is not in conformity with the Constitution. Then there's the validity of a will, the legal adequacy and sufficiency of a will that is being contested. If it is held to be valid, it means the will is a genuine one. Now you can understand that valid means legally binding, sufficient, justifiable, complying with necessary regulations, formalities. For every estate that I have a claim in on, I'm going to want to make sure of the validity of the will. Is it valid? It means the will is a genuine one. Now, I know America's oaths of office didn't want me involved in their estates, but I didn't want to be involved. But since they wouldn't involve themselves in my personal problems of having a protection order issued against me, I thought I should just read from the state's response that creating incentive to mandate personal service as a further requirement of the offensive violation of a protection order would undermine the legislative intent by creating an incentive for domestic violence perpetrators to avoid court appearances and avoid personal service. It cannot be said that a legislative purpose to impose personal service plainly appears as a further requirement for establishing violation of a protection order. It is contrary to legislative intent to undo a valid order for protection. Now, the state would say that this is a valid order for protection. The dictionary would say complying with necessary regulations and formalities. Now, when you think about what is valid, let's say you issued a protection order where I was not given actual notice of the hearing. State law requires that the respondent be given timely and proper service so as to protect the constitutional right to due process, so that I would not be deprived of life, liberty, or property without having the valid, necessary formalities and regulations so as to comply with the law. Now, when you issue a protection order where there is no signature, it's not valid. Now, I know the state says, well, the commissioner signed it, so it's valid. But I would say it's invalid, and for every instance that I informed anyone of their legal obligation to support and defend my constitutional right to due process, and they decided they didn't want to get involved, I just got involved in every estate of the United States. Now, your refusal to enforce the guarantees of the United States Constitution means that I am going to involve myself in every estate of every elected and appointed oath of office for the next 20 years. Now, as long as they know that my rights are being violated and they decided that they weren't going to do what they had sworn, I'm now going to be involved in their lives. Do you understand that when I informed law enforcement, When I documented that the protection order is invalid and they refused to remove it, I just decided that I'm involved in every oath of office for the next 20 years, and I'm going to make sure that every will they have is genuine and valid, or I will contest every estate of the United States to every person that's been elected to office. Oh, did you think I couldn't do anything?